Okay, good afternoon. I'd like to introduce our third panel today. And the name of the panel is Cyber War, Does the Law Provide Adequate Guidance? This panel will address the question of whether current international and U.S. law provide adequate guidance in the governance of cyber warfare. Just as a way of note, the United States recently stood up a cyber command, and General Alexander was giving his remarks to the Senate regarding the new cyber command. And his remarks one of the remarks that stood out to me was this organization or this agency was not going to be a defensive organization. It was going to be an offensive organization that they would use to defend the United States. So today's moderator, Professor Oliver Goodenough, Professor Goodenough's research and writing at the intersection of law, economics, finance, media technology, neuroscience, and behavioral biology make him an authority in several emerging areas of law. His academic appointments reflect the breadth of his studies. At Vermont Law School, he is a professor of law and the director of scholarship. He is also currently a faculty fellow at the Berkman Center for Internet and Society at Harvard University, where he is co-director of the Law Lab Project, a research fellow of the Grutter Institute for Law and Behavioral Research, and an adjunct professor at Dartmouth's Thayer School of Engineering. He has also been a visiting research fellow at the Zoology Department of the University of Cambridge, a lecturer in law at the University of Pennsylvania Law School, and a visiting professor at the Neurological Department of the Charité Medical School of Humboldt University in Berlin. Professor Goodenough has written on a wide variety of subjects relating law, business, the internet, and cognitive and behavioral science. Please join me in welcoming our moderator, Professor Oliver Goodenough.
Thank you very much. I'm quite excited to be able to moderate this panel. It's a subject in which I have more interest than expertise, and I'm looking forward to learning a lot as we go forward. We are very lucky in having two very distinguished panelists to open up this topic to us. As mentioned, this is a topic as timely as today's newspapers, whether it's the various kinds of espionage and other attacks on the U.S. or the U.S.'s new command, which, as you've heard, is not necessarily defensive in its nature. And indeed, one of the things that always occurs to me in this topic is, as we explore the law, is who do we think the laws are going to constrain? Is it other folks or us? Anyway, it's an interesting topic in that way. But our two panelists are deeply involved in these questions, and we'll, as I say, hopefully open them up to us. We're going to aim to have them finish their prepared remarks by about 40 after the hour, and that will give us 20 minutes, I hope, for some lively to and fro. Our first panelist is Jamil Jaffer, who is currently the senior counsel to the House Permanent Select Committee on Intelligence, and is also an adjunct professor at the George Mason University School of Law. He has a distinguished practice career that involves the government and private practice as well. And his education attainments are strong. He is a BA from UCLA, a JD with honors from the Chicago Law School, and an MA from the United States Naval War College. So he pretty much boxes out this topic. I also will introduce now Colonel Jody Prescott. He is a retired colonel in the U.S. Army. He's a senior fellow at the West Point Center for the Rule of Law. Also, I believe currently an adjunct at the University of Vermont's Department of Political Science. He, in fact, got his BA from the University of Vermont, JD from the University of Maine, and an LLM from Georgetown. His work in and out of both in the military and out of the military is distinguished and is related to this topic. So, without delaying it further, I'm going to turn this over to Jamil. Those of you wondering, where is Jamil? Jamil is in Washington. His staff is involved in some of the budgetary pieces, and he was, Jamil, am I right in understanding that you essentially were told, you stay in Washington today, and you were able to carve this time out to participate by phone. We have the phone hooked up to the microphone here. He may not be able to hear questions coming back to us, so I may act as an interface for questions as we go forward. Jamil, is this working for you?
I can hear great. Can you all hear me?
Yes. Very well, thank back the microphone off just a hair. Pretty loud. You're
perfect. So I am. I'm stuck here in Washington, D.C. I just should preface my remarks by saying that whatever I tell you today are my views and my views alone, not the views of my current or my former employer. So I currently work. My immediate past job was at the House Intelligence Committee, where I worked on a lot of things, including the House passed Cyber Intelligence Sharing and Protection Act, colloquially known as CISPA, which has gained a lot of attention on the internet as sort of a surveillance law in some corners, a very well thought out cyber protection bill in others. It all depends on where you sit on any given day. Today I work at the United States Senate Foreign Relations Committee, where I work for the ranking member of the committee, Senator Bob Corker from Tennessee, and I serve as Chief Counsel on the Foreign Relations Committee. So my take, sort of where I sit today on cyber, is a little different than where I sat just a month and a half ago. A month and a half ago, we spent a lot of our time thinking about the threat from China, the threat from other nation states, both from an attack perspective as well as a collection perspective, and I'll talk a little bit more about that. But today we think as the Foreign Relations Committee, we look at both the threat as well as how the U.S. might respond, not necessarily through active collection or actual sort of cyber offensive cyber warfare, but through things like trade measures and economic relationships and the like. And it's important to think about the sort of whole of how the government might respond. You can see just in the last few weeks, maybe in the last month and a half, the U.S. government has dramatically changed, I think, its posture towards China when it comes to China's well-known and well-discussed cyber activities. We've seen a lot more activity at the highest level of the U.S. government, engaging with the Chinese at the government level, as well as just sort of publicly calling out the Chinese on some of the activities that the government has been reticent to talk about for a long time. My former boss, the chair of the House Intelligence Committee, talked a lot about the threat from China, but prior to that, not a lot of people have been talking in the government, talking actively about what we knew about the Chinese. And so let me talk a little bit about that, and then turn to this question of the laws surrounding cyber warfare and cyber attack and the like. First, the threat, the threat really comes in sort of, I think, two different flavors. There's the threat, as everyone knows, the one that's most popular to talk about, which is the threat of some catastrophic attack on the nation, whether it's on our civilian infrastructure, the power grid, nuclear power plants, our banking system, or the like. The threat to our military systems of an offensive attack, whether conducted by asymmetric actors like terrorist groups or by nation states, and then of course, and the government generally. And then and that's sort of the threat that's popular to talk about, the threat that I think a lot of people worry about, and that sort of motivates a lot of the discussion around cyber activity. The threat that we spent a lot of time thinking about at the Intelligence Committee, and the threat we spent a lot of time talking publicly about, my boss and his counterpart of the Democratic side, ranking member Dutch Ruppersberger, in whose district NSA and U.S. Cybercom is actually headquartered. Both our bosses have spent a lot of time talking about the threat of cyber espionage, and specifically cyber economic espionage. Now, it's sort of ridiculous for me as a former, House Intelligence Committee staffer and former executive branch staffer in the national security community to suggest that, the U.S. government does engage in espionage. Of course we do. Everyone knows it. We do it. Everybody else does it. It happens. We steal other government secrets. They steal our secrets. It's the nature of the business. What is unprecedented, though, today is the scope and scale of the economic espionage being conducted by nation states, and in particular, I'll just say it, China, against the United States. The Chinese are engaged in an active, aggressive campaign to come after United States private sector companies, steal their core research and development secrets, and give those secrets to Chinese companies, both state-owned and non-state-owned or state-influenced companies, and make cheaper products that are essentially knockoffs of U.S. products without the same research and development costs that the U.S. government faces. Now that's a huge, massive problem. It's a huge, massive problem because it's not just a military or a government problem, it's an economic problem. The Chinese and by the way, this is not just the Chinese, but the Chinese are I'd say, the worst actor in this area. There are other nation states with advanced capabilities. Recently, Secretary Panetta talked about or former Secretary Panetta, I should say, talked about the threat posed by various other nation states to include the advancing capabilities in cyberspace of Iran. And he also talked about recent attacks, I guess I call it moderately offensive attacks, not necessarily by a nation state, but against our banking system of the sort of distributed denial of service variety. So we see a lot of this going on, and I guess what I should turn to now is sort of the law of cyber attack. And all of you who look at this issue know that there are a sort of a range of laws that apply. Obviously, there's the jus ad bellum, right? The sort of before you go into war, what constitutes an appropriate use of force? What constitutes use of force at all? In cyber, that gets very hard, right? Does it have to have a sort of kinetic-like effect? What is a kinetic-like effect in cyberspace? How bad does the damage have to be? Is espionage enough? Is espionage very expensive enough? Does it require a computer to break or a physical system to break? These are all hard questions to figure out what constitutes an attack, and then obviously once you're and how you can respond and when self-defense is triggered, and if and when that's triggered, then we talk about the jus ad bellum, and the question being, what are the rules that apply to you in your war? What is proportionality in cyber warfare? What is necessity? What is distinction in a world in which it's very hard to tell who the enemy is, and it's hard to attribute actions to a nation state or to a non-state actor because of the way the internet functions and the open nature of the internet? How do you distinguish between them? And what about neutrality? I mean, we all know that computer servers live in physical space, right? They sit in a country of some sort or on an offshore island or whatever it may be, or sometimes even in outer space. But even though they sit in a particular place, can you act against it? So say the Chinese are using as a hot point a server in the Comoros Islands. What obligation does the U.S. government decide to take action on this Chinese server in the Comoros? What obligation does the U.S. government have to notify the Comoran government of their activities, if any? And what happens if it's in the U.S.? We, in our surveillance context, and I teach surveillance law at George Mason, in surveillance context, we treat things that happen inside the United States, or we have historically until the Biden Amendments Act, treat things that happen in the United States very differently than things that happen outside the United States. And because technology has changed, we have changed our laws to account for the fact that sometimes when you're targeting a foreigner, you might collect in the U.S., and you want the same laws that apply to collection outside the United States, or similar laws, to apply to that collection. So what do you do? How does that affect cyberspace? And then, of course, there's the whole question of international law and what aspects of international law apply to all of this. And do we need a cyber convention on cyber warfare? Interestingly, the Russians, the Uzbeks, and the Kazakhs got together and have proposed something of a cyber convention about a year and a half ago at the UN. And I dare say that if they're proposing it, you can guarantee that it's not really about cybersecurity. And as you look at the convention, some of the aspects of it are obviously, there are some positive aspects of it, but there are some very troubling aspects of it too that deal with how to deal with internet freedom issues in their own countries, and sort of setting a standard for the world that might not be one that a country that believes in freedom of the press and sort of freedom to stretch your government, senior government for reaching grievances might agree with. And so I guess where I'll leave off and leave some time for questions after the Colonel has a chance to speak is, look, there are a lot of questions here. The law governing cyberspace, there's a lot of laws that apply, certainly, but the challenge becomes how do you apply them, where do you apply them, and how do we think about warfare, both offensive and defensive, in the context of the cyber environment.
Great, Jamil. Thank you very much. I appreciate that, and we will put a hold on you for a moment. I understand you're going to put us on mute for a little bit.
I will.
And we will hear from Jody Prescott.
First, I'd like to thank the organizers, the Federalist Society and the International Law Society, for inviting me to speak, particularly about such a timely issue. It's great to come back to present at Vermont Law School. It's nice to look out in the audience and see familiar faces from moot court. Today, as Jamil said, one of the situations that we're facing in terms of figuring out applicability of the law is there is a lack of international consensus, specifically with regard to the degree to which the law of armed conflict applies to military operations in cyberspace. And the reasons for this lack of consensus, well, perhaps there are three big ones that stand out. One, cyber is fairly new. Two, cyber is very different than geophysical warfare. And three, the circumstances under which the rules and regulations and the degree to which the law would be applicable seems to be primarily discussed by the nation states in classified settings. It's not transparent to us. We only get leaks in the newspaper sometime, or redacted unclassified copies of the documents that are provided to the Congress by the Department of Defense. Why is this important? Well, I'm concerned that this lack of transparency is inhibiting the robust discussion that we need to have as to what the rules really are and what they should be. And in terms of talking about why transparency is so important, what I would like to do is I'd like you to consider a perspective perhaps quite different than that is ordinarily discussed, at least in the academic literature. I'd like you to consider the applicability of the law of armed conflict from the perspective of the responsible cyber commander, and importantly for this audience, her legal advisor. What does it mean in terms of applying the law of armed conflict in military operations such that a cyber commander can be held to the standards that we expect in the geophysical world for criminal responsibility for war crimes? When we approach it from this perspective, I think you'll see that it becomes even more apparent how difficult the problems may be in terms of sorting out the issues because of the complexity and the holistic nature that the solution must achieve in order to be effective. And before I go further, of course, this is all just my own opinion and nobody else's. So, very recently, within the last couple of weeks, we've had the official launching of the Talon Manual, an extraordinary piece of work put together by a group of law of armed conflict lawyers. Have been spending quite a while on it. It's been done in cooperation with the Estonian Cyber Defense Center of Excellence. Of course, the Estonians had a particular dog in that fight as a result of things a couple years ago. And the important thing about this manual is that it begins to set, and quite frankly, it seems to be reflective of, an emerging consensus as to the extent to which the law of armed conflict applies to military operations. This manual is jurisprudentially conservative, potentially politically conservative as well, but at least jurisprudentially conservative. The authors of the manual go up to an edge and no further. They recognize that there is a lot beyond the extent to which they're willing to go as to the degree that the law applies. But in terms of setting out the standards for what we're looking at for the applicability of the law of armed conflict, I think it's fair to say they come down to the point of, if it is intended or results in a kinetic-like effect in the geophysical world, a cyber military operation is going to be considered an attack. It's going to be subject to the law of armed conflict. Now, the important thing, of course, is that there's a lot beyond that. There is a lot that happens in cyberspace that goes beyond having that kind of manifestation in the geophysical world. But this manual, and I think one of the great contributions of this manual, is to set at least a marker. Set a marker in terms of, if we were to take the law as we understand it now, this is the extent to which it would apply in this new area. Now, on the other hand, when we look at other documentation, particularly from the United States, the U.S. is perhaps out in front in this regard in terms of the amount of information that is available with regard to the official U.S. position, the official government position, on the extent to which law of armed conflict applies in cyberspace. Other nations have addressed it to a degree, some have not at all. Surprisingly, for example, the Netherlands has been very forthright in this. The Brits, not quite as much, and perhaps that's why they were taken to task a while ago, several months ago, by the Parliament for the degree in which the Parliament wanted to give more information and more reassurance as to what the Ministry of Defense thought was actually going to be the case. The Dutch, on the other hand, the Dutch have, in a very Dutch pragmatic and transparent fashion, have set out a very clear standard in terms of what their government views the role of LOAC in cyberspace to be. From the U.S. side, though, what we're looking at are acknowledgments that law of armed conflict is applicable, but that it might need to be tailored as appropriate to make up for changes in circumstances in the cyber situation. There's also a significant amount of at least presentations and speeches given by Department of Defense officials that suggest that there is potentially a gray area. And this gray area is we're talking about because this is probably where the trouble is going to come from. There are those things that rise above mere cyber annoyance that a nation is going to be concerned with. There are those things, in fact, that even though they don't result in manifestations of damage to things or injuries to people in the geophysical world, a nation might be so upset about that they would consider it akin to an attack. At the moment, these red lines are unknown. They are not declassified. They are fuzzy. So we have this window, this gray area between what might in fact look like an attack, what looks in fact just like annoyance, an enormous amount of space in between, meaning that it's a judgment call on the part of the actors who act within this area as to what kind of response they're going to engender. So, for example, we might consider something to be merely reconnaissance. The country whose system we were snooping around in might justifiably say, yeah, but cyber reconnaissance is potentially like the next step to cyber attack. It happens so quickly, there's really no meaningful differentiation between the two in terms of how we perceive it when you're messing with our national critical infrastructure. So on the one side, we have a very conservative legal document that talks about the extent to which the law of armed conflict applies. On the other side, we have national policies that recognize below this threshold, there's an area of action that is very, very concerning. So where do we go from here? And what does this mean, more importantly, for the person who finds him or herself being a cyber commander, responsible for engaging with offensive cyber weapons or responding with certain defensive weapons that then become active? Potentially, and you gotta forgive me, I know this is geeky, but I gotta do it. Okay, where else but a cyber conversation could I throw a picture of Star Trek and actually have a straight-faced conversation about it? Potentially what we're looking at with regard to the cyber commanders is that we're looking at like a 3D game of chess. There are at least 3 levels, there are potentially more, but there are at least 3 basic ones from a legal perspective. At the very bottom, things that happen just in cyberspace. Legions of electrons mass and battle each other. The carnage among zeros and ones is terrific, and nobody notices. It's just cyber. It's just electrons. At the other end, this is where the law of armed conflict comes in. We have cyber actions that are taken, either intentionally or unintentionally result in people getting hurt or things getting broken on a significant enough scale in the geophysical world that we look at this as an attack. Up here, very clear, the law of armed conflict applies. Down here, what's happening in cyberspace, this massacre of data and metadata, nobody cares. But this gray area, the second level in between, how can we know, for example, what the results are going to be of particular actions? How well have we scoped out the electronic battlefield, the cyber battlefield, to know that, for example, our actions aren't going to ripple into the geophysical world? And were they to ripple into the geophysical world, how would we know where to look for them? How do we map that? Becomes very, very problematic. These different levels, importantly, they have different rules. And guess what? The pieces go from one level to another level. So you conceivably have military actions, tools, programs that start in one level, move to another, and result in something happening in a third. And how can you tell? With what degree of confidence can you tell? Because this is very important for the responsible cyber commander and for her legal advisor in assessing proportionality, in establishing distinction. How can you tell when a snark isn't going to turn into a butcher? What level of confidence do you have in that? That becomes very problematic. And it's a matter of concern, I think, in terms of thinking of the legal education of the legal advisors who are going to be advising these commanders, and growing these commanders, teaching these commanders, and training these commanders to be able to think like this on 3 different levels, depending on what's going on, maybe even simultaneously within cyberspace and related areas in geophysical space. When we look at it from the perspective of the responsible cyber commander, particularly within the last year or two, there have been very interesting doctoral dissertations and studies that have been presented as to what current cyber operators perceive to be the problems in the area in which they're working. And I've put a number of them up here on, and list them up here. Complexity is a problem. Not just that it's complex, complexity in the sense of non-linearity, complexity in the sense of chaos. And quite frankly, when you get right down to it, in my view, I think the takeaway from von Clausewitz is that military geniuses are actually quite rare. The one who wins the battle, she's the one who can manage chaos better than her opponent. It doesn't take genius necessarily. Technical challenges with discrimination. Jamil alluded to some of those already. How do you know that what you're attacking is in fact the thing you should be attacking? Is that really where the attack came from? And importantly, in terms of discrimination, how do you tell what's civilian? How do you tell what's military? Because you should only be attacking military targets, of course. Now, of course, cyber itself is dual use, right? The backbone of it is civilian. The military makes a great deal of use of the civilian part of cyberspace. How do we distinguish, and to what level are we able to distinguish to make sure that if we were to do something, we would in fact be complying with the law of armed conflict? This last one is very important. It's the role of autonomous decision-making processes. So I'm not talking about the machine. I'm talking about the brain in the machine. And I'm talking about the programs in the brain in the machine. I am concerned about this, but not for the reasons that were brought up on the earlier panel. Actually, I don't think those are big problems. My concerns go deeper, and maybe somebody will ask me a question about it during the question and answer period. So, how, given the extent to which these concerns have been manifested by the cyber operators, how can we best interweave the threads of the law of armed conflict into the selection of personnel, their training, the education that they get, the operations they conduct, in a way that it is going to be seamless enough to allow them to be sophisticated enough to operate on 3 different legal levels at one time? I think that's a big challenge because it requires a very holistic approach in order to solve it. It's not just a question of the law and reading in a book what you should or should not do. We're talking about something much more fundamental here. And quite frankly, we're talking about something very, very expensive and very different from the way the military is accustomed to doing business. So for example, this last year, General Alexander, the Cybercom commander, showed up at DEF CON wearing a black t-shirt and blue jeans. He was looking for recruits. Do hackers make good cyber soldiers? They seem to be a rather ill-disciplined bunch. They seem to be breaking the law regardless of what their motives are, but they've got the technical proficiency to do what needs to be done. Does a good cyber soldier make a good cyber commander? Very, very important questions, very, very important differences, potentially, in terms of how we select and train people. In terms of the autonomous decision-making processes, there's a conference, a 4-day conference being held in the beginning of June in Estonia at the Cyber Defense Center of Excellence that is solely dedicated to talking about autonomous decision-making processes in cyberspace. That's how important this topic is right now. And quite frankly, you know it's important at least to the Estonians because it's their little cyber center and it's what they're concerned about at the moment. These other approaches, in terms of weaving the threads in, are very important as well. How do you visualize cyberspace? If you're a cyber legal advisor and you're working with a cyber commander, how do you know you're seeing the same picture she is seeing? How does she know the picture that she is seeing is the accurate picture? How long have you worked together? Do you have a habitual training relationship together? All of these things are going to become very, very important, I think, in terms of conducting cyber operations. So, in conclusion, I think transparency, it's not just that transparency is good. Transparency is important here because cyber is so different. In the geophysical world, we like drones. Okay, I got it. They're controversial at the moment. But you can see them, you can touch them, you can shoot them down. You understand how they're going to act in the geophysical world. Cyber, it's different. It's different. And this common knowledge that we would have just in terms of being sentient beings in the geophysical world, it doesn't carry over into cyber necessarily. That's a whole different realm. So this transparency would be good to trigger this discussion about all these things that need to be done in terms of coming up with the rules that are going to be applicable, the rules that we would be comfortable as members of the international community following and having followed by others. This area that we need to look at, this one that is most tricky, this gray area between these red lines that exist but we don't know about in a classified fashion, and these things which are mere cyber annoyance. This is the area where we need particular attention. Certain U.S. documents suggest that even in this area, law of armed conflict principles might be applicable by analogy, not because they're legally required, but perhaps because they're useful. Think about the complexity then, and this is where I'd like to leave off. Think about the complexity then for a cyber commander when she's trying to figure out which level she's working on. She's got a place where law of armed conflict doesn't apply at all. Law of armed conflict might apply by analogy, and then, oh yeah, when you're hurting people and breaking things, that's when law of armed conflict applies. And it could go ping, 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 back and forth potentially. When you look at it from her perspective, and you look at it from the perspective of her legal advisor, I suggest to you that it shows the need for greater transparency to foster the holism that's going to be necessary for us to be able to do this effectively. Thank you.
Thank you very much, both of you. I'm going to take the moderator's privilege here and make just one or two brief comments myself before throwing it back to the panelists and then out into the audience as well. One thing I would mention is that there's every reason to believe, by the way, that Vermont Law School has experienced a cyber invasion from a third-party country. We have had indicators that occurred. It is a reasonable supposition, although our tech people may contradict me on this, but it's my working supposition that all of my emails are being potentially read by a third-party country under the circumstances that went down. But I would also mention, by the way, that it is also a reasonable supposition that all of the emails that we send here are potentially readable by the United States government. We should be aware that domestically there are splitters in the fiber network that sends a great deal of the data that goes through in a raw form into central repositories and the United States government. So again, you just at the level of kind of this annoyance piece, I want people to understand that we are not immune to it here in Vermont. And also the piece that I keep coming back to, which is, be careful who you're accusing of what in this context, because we are active. The other comment I would make is that at least the best publicized of the effective sort of breaking things stages that's ever gone on is something that's called Stuxnet. Many of you will have heard of it, but I'll just quickly reiterate. It's essentially a virus, a computer virus, a worm that was turned loose, whose sole purpose, or at least whose purpose that we know of, was to essentially take over centrifuges of the brand bought by Iran, and to A, turn them up to a velocity that would cause them to damage themselves, and B, to obscure that from the controllers, basically to give false readouts on velocity. And there is every indication that that was extremely successful, and that it severely damaged the Iranian uranium refining capacity, and is one of the reasons why we have still, at least apparently, some time left before whatever red line that either Israel or the U.S. government has made design occurs. So we are now, we have never claimed that, the Israelis have never claimed it. It is at least a reasonable supposition that that attack originated at least in part with us and was extremely successful and broke things. So you know, in a sense, we have done some of that in a conflict of whose areas of gray areas are significant. So I would put those two pieces out there for comment by our panel as at least concrete exercises in what's happening. You know, some place like Vermont Law School being subject to interception and by outside governments, and also our own government's activities, particularly in terms of being at least the putative source of a real attack that undertook real things. By the way, I should also mention, I actually consult to a branch of the U.S. government too, so I should say all these same things, which these are all my views rather than somebody else's. So I will repeat that. Jamil, you want to pick up on some of that?
Well, I think I'd like to leave more time for questions from the audience, but the one thing I will, and it has nothing to do with cyber warfare, but I'll just sort of on the surveillance point that you just made. I would note, you know, that U.S. law requires that for surveillance targeting a U.S. person anywhere in the world, and certainly inside the United States, you're required to go to a court, whether it's a court for a Title III wiretap or the FISA court in the foreign intelligence context for a court order. And so, you know, whether or not it's sort of these allegations about splitters and the like and whatever else that are out there, you know, it should be clear to everybody that when a U.S. person, which includes a citizen or a green card holder, is targeted anywhere in the world, the U.S. government has to get a court order to surveil you. So that's, you know, I just want to make sure we sort of put that marker down. You know, of course, if the U.S. government's acting outside the law, that's a whole other story. But as far as I'm aware, that's not going on. On the cyber warfare, I'd like to hear what the audience has for questions, or you know, if Colonel has thoughts or comments.
Thank you both. All right, then I will throw it open to questions from the floor. Folks with questions, yes.
Mike Lewis from Ohio Northern. We have talked about offensive cyber largely in the context of basically going after others that are coming after us, right? So if China is either trying to steal state secrets or commercial secrets, can we use cyber weapons or cyber programs to disable or obstruct or prevent them from doing so? And much of this obviously occurs in the somewhere between cyber annoyance and LOAC system. But another part of offensive cyber is, no kidding, full-blown war in which you're using Stuxnet type weapons to disable armored divisions and airborne radars, or I mean, you name it. You can use those kinds of things that can be embedded and implanted long ahead of time to prevent any weapon of war that depends on computers from operating when it needs to. Do either of you have any sense for how much of that sort of work Cyber Command is involved in? I know I've talked to some people there, and there is a level of frustration that perhaps that side of things is very much in the back burner. And I don't know if either of you have heard anything otherwise.
Jamil, were you able to hear that?
I was.
Great.
So I can't really answer that question. Well, let me do this. You know, the U.S. government obviously has capabilities that range the spectrum. Getting into detail of what those capabilities are is obviously almost impossible in an unclassified setting. You know, I think there's a difference between having capabilities and how and when you might employ them. So if you're hearing frustration from folks in Cyber Command, you know, some of that might come from we don't think we have the capabilities, some of that might come from we have the capabilities but nobody's letting us use them, right? And those are two different, very different and importantly different issues. And then, you know, obviously, take for example this whole claim that's in the newspaper and in all these books about Stuxnet, right? You know, there are plenty of programs in the government, both at the Department of Defense and in the intelligence community, that are highly compartmented. This may or may not be one of them. I have never been sort of in my government job told about the program that has been labeled Stuxnet in the media and has been talked about in various books. So if there was such a program, I certainly wasn't read into it. But you know, there's a lot of talk about it. So you know, and stuff is breaking. So clearly something's going on, whether it's us or someone else or whatever it is. Clearly something is happening there that's not probably not from you know that was intended to be the way these things work. So clearly capabilities exist. Someone has capabilities, whether it's us or someone else. Obviously, we have some of the best computing brain power in the world, and some of the most powerful supercomputers, publicly disclosed supercomputers in the world. You know, we're up there on the top 10 list annually, as is China, as is Russia. And so you can assume that, you know, whoever has these capabilities, somebody's got them, and we're pretty good at computers, so we probably have something. And it's just a question of when and how we might use them, and what agencies might use them, and how they might deploy them. And so, you know, Cyber Command is a big and growing organization, so it's not surprising, like anything, that people will be frustrated if they have tools and aren't able to use them, or if they want to build bigger, better tools. This is sort of a function of, you know, being the government. When you're the government, you want more territory, more responsibility, you know, and so that you're frustrated when you can't use it.
You have a brief follow-up?
Well, yeah, the brief follow-up was, this is less of, you know, wondering if you could tell me what the capabilities are. Obviously, to the extent that you know you can't, and I figure that. It's more of, this struck me as sort of a Billy Mitchell moment in the sense that in the 1920s, he was the guy saying we should use air power. And, you know, we had the capability, we had bombers. The question was, were we going to spend money on developing bombers, or were we going to spend money developing other kinds of weapons? And there was a big back and forth about that, and my sense is that within cyber there is a similar. Are we going to put resources, money, whatever, into the truly offensive, game-changing, change the way an armed conflict is fought, or not? And that's sort of my concern. I don't know if there's anything either of you can say to that or not. But.
Well, I would just comment that as you heard from our conference organizer, that there is the recent establishment of a more formal command within the military to pursue exactly these measures. That, to me, would be indicative that the question about whether or not we are supplying more resources has been made. I would also mention, by the way, this is indirect knowledge rather than direct, but I understand that command is hiring. And for students with an interest, you might look into this, particularly those with any kind of background in law or questions. That my understanding is that it is indeed a growth industry, and you might if that's something that interests you, keep it in mind. Other questions? Yes.
Thank you. My name is Sam Bork, and I'm a third year here at Vermont Law School. My question was inspired by Colonel Prescott's talk about both coming up with the internal red lines and also sort of the rules that we have to create that don't yet exist on how we'll approach these subjects. And my question is, given that we're not starting with a blank slate, we're starting with a place where we or our allies or some benevolent force has Stuxnet and the various flame-related programs, and where our own domestic side is thoroughly penetrated by China along with others, what effect does that have on the rules and the red lines we come up with, given that we're starting with all of these things that have already happened and coming up with the rules afterwards?
So I think what you're saying is we have a decent empirical basis upon which to begin thinking about the rules we might like to have. Perhaps we do.
Jamil, would you have a follow-up on that about this? It actually leads me to a follow-on question, which is one of the interesting questions that you both raised is what is, the traditional laws of armed conflict may or may not be a decent starting point for many of the things we see. The existing rules of those laws come from a long experience, a sad experience with armed conflict. If we're moving to a cyber conflict world where how, as you rightly point out, those rules may or may not fit in certain kind of contexts, but we have the basis for even beginning to imagine, and perhaps the process that you were saying with the Estonian Center and the new set of rules would provide some of that. How do you feel? How do you feel they fit with what we're seeing? Or as you were describing them, are they basically conservative in saying if we get into the traditional rules of armed conflict, we're okay, we don't know what's going on in cyber? Is that a too strong a characterization?
So, yes, I agree with you. I think in part we have got the start of an empirical basis to begin to look. I think, and I don't know, I only know what I read, right? So what has become apparent to me though is that there appears to be a schism in how different countries look at cyber. The United States, particularly the Obama administration, has made it clear that it considers cyber part of a global commons, to be something over which stewardship should be exercised, rather than sovereignty. Pronouncements from different officials in China suggest, and Jamil alluded to the 4 states who brought out that compact of, I think they're cyber rules of conduct. They take a different perspective. They're more concerned about sovereignty than openness. And I think there is a very large gap there that needs to be bridged before we can begin thinking about, as the United States has put it, what it means to work with the like-minded in cyber. What does that mean? Do you have to be like-minded as to global commons versus sovereignty? Do you have to be like-minded as, for human rights as compared to authority? Do you have to be like-minded in terms of how you view the law of armed conflict applying? And so that even though there is the start of an empirical basis of some experience with which we're familiar, it's a start at least, and it gives us an idea that there's something that we can point to and say, well look, it actually can happen. But is it developed to the degree that led to, say, for example, the 49 Geneva Conventions, in terms of the horrible experiences that we had, the vast horrible experiences that we had in World War II? I don't know that we're there yet, but it has to begin somewhere. And so where does the conversation begin? And wouldn't it be best if this were to be a transparent conversation, so that if this were engaged in the open, as compared to that which must truly remain classified?
Thank you very much. Yes, next question.
Gentlemen, how you doing? My name is Ben Dexter. I'm a 3 Elton Moon Law in Boston. Question, if this kind of assumes some facts, not evidence, by the way, this topic is something I haven't explored, but it blows my mind. I noticed we're talking about rules for cyber warfare, and one of the things that I was thinking of is that it seems like one of the major benefits to cyber warfare is the fact that you can do it, and you can't find out who did it. The party responsible, it may be difficult to figure out who they are. I'm thinking, for example, the Stuxnet thing, we assume that we think we know who's responsible, but we're not exactly sure. If that's the case, in the future, if parties are able to be anonymous in their cyber warfare, how do we ensure we don't put ourselves at a disadvantage? Should we follow the rules, but yet other countries, other war makers, or whatever the case may be, do not?
Well, just to share an impression with you, how many of you got a chance to see the HBO miniseries Generation Kill, about a group of Marines who went into Iraq, forced recon Marines? Okay, there was a lieutenant who was the platoon leader, Nathaniel Fick. After he got out of the Marine Corps, he then went to Dartmouth, graduated from business school there, and there was an announcement in the press 2 weeks ago that he had accepted the position of a chief executive officer for a software company whose main product was something called Bonesaw. And what Bonesaw does is it maps cyber. And so this technological problem of not being able to attribute, I think it probably has a technical solution. And maybe people are getting there. But of course there will be countermeasures that will evolve against Bonesaw if that's what it does. So I wonder if what we're seeing is perhaps a snapshot in time of technical development and one system fighting against another system before the countermeasures are developed. But I mean, your concern is squarely on point.
And if I may add, by the way, something like Bonesaw has clear national defense pluses in the hands of folks who are looking for where an attack comes from. By the way, the current investigation of where the cyber attack against the South Korean business establishment is up against some of this. They announced a place where it came from. Oh no, maybe not. You know, and they have a pretty good target of suspicion in that case. But realize also that exactly these same tools allow repressive governments to find out where those annoying anonymous postings are coming from. There are backdoor systems like Tor and things like that, which are designed to provide anonymity to people in Myanmar and other places where repression is going on. And so some of the principal consumers of these identification methods are governments that are perhaps not as like-minded as we would like them to be. Thank you. Jamil, would you have a response?
No, I think you guys have covered it pretty well.
Thank you. Thank you. Okay, next.
Good afternoon. I'm Ernie Ciccatelli. I'm a local attorney and a VLS alum. And my questions, first of all, I just want to say, I don't want to include anything that's clearly a law of armed conflict case, such as manipulating or hacking air traffic control or something like that that could cause a airline to go down, or something that would cause a nuclear power plant to blow up or something like that. So I'm not talking about that, but anything short of that, something that causes, let's say, severe economic damage, for instance. What I'm wondering is, in terms of the damage, how does cyber attacks really differ from the kind of damage that was caused, for instance, by actions taken by Wall Street that have caused reverberations around the world? And I'm talking about not only the United States receiving, but also sending problems too. Why should there be a different set of responses to that kind of massive damage? Why should there be a difference between the kind of damage that's caused by cyber attacks versus the kind that's caused by hands-on maliciousness? I mean, is there even a difference between hands-on maliciousness, sabotage, and cyber sabotage?
Yeah, fair question. I mean, and it comes down perhaps to a question of proximity, maybe a question of intent, maybe a question of the modality in which it's being exercised.
I'd like to assume, let's assume it's all on purpose.
On purpose. Completely on purpose, malicious. Somebody messes with Wall Street's data recording system so that all records of stock trades are lost for the last week. The reverberations of that economically could go worldwide, but they would be indirect. Would people suffer? Sure. Just as the people in Estonia suffered when the patriotic hackers began doing the massive DDoS against the Estonian cyber system.
Well, what I'm actually asking is that what we have seen since around 2007, 2008 is huge. I'm going to call it hands-on damage caused by Wall Street. Okay, we've had one set of responses to this massive damage caused all around the world. And now we're talking about a sort of remote sort of damage that can be just as bad, but it seems here in this panel, you're talking about one kind of response that's very belligerent. You know, you're talking about, you use the word war several times in this discussion, and yet you don't use that same word in relationship to the damage that's causing all kinds of people to be out of work, all kinds of other problems. And that's why I'm trying to see, why is there a difference between handling one set of extreme problems and other extreme problems that are just as damaging?
So, for example, why are the sanctions against Iran legal under international law? It would appear people in Iran are suffering. From what I read, the inflation rate is tremendous. There's scarcity of certain goods. People aren't able to recognize their full economic potential. Iran's having the financial screws applied to it. Yet everyone seems okay with this under international law. There are many forceful measures that are taken under international law which are completely legal but very unfriendly.
Jamil, you have a comment? And then I'm going to ask our panelists to wrap up. We've got about a minute and a half left, so I will ask them perhaps to take a wrap-up moment. I apologize for anyone else in the queue, but I think we're getting to the end. Jamil, do you have a comment?
No, but I'll just use this as a wrap-up moment. Thank you all for having me. It's been great. I really appreciate it. Sorry that I had to come in by phone. The Senate is in the process of considering nearly 600 budget amendments that do almost nothing, but they're going to pass a budget, hopefully, that is reasonable, or at least we passed a continuing resolution that kept funding it reasonably at lower levels than in the past. So no matter what you think of sequestration, good or bad, it may be a bad way of doing things, it's at least cause the government to look at its spending and cut it. So that's why I'm stuck here. Sorry I came by phone, but thank you for the interesting questions and the thoughts on cyber warfare, and appreciate the chance to participate.
Great, many thanks, Jamil. Jody?
Jamil, are you still on?
I am.
A small favor, I'd be very grateful. If there's something you could do to avoid furloughs and ICE, I'd be very happy. Just saying.
Well, it's funny. The real problem with sequestration is it's just a very blunt force instrument. But, at the end of the day, the government has got to cut spending. And this may not be a great way to do it. And furloughs and ICE are not ideal, obviously. Nor are furloughs the Department of Defense. But, the place we are at now, I'm saying, it's just unsustainable. It's really unfortunate we had to come down this road. And hopefully saner minds can prevail. We can find a middle way forward.
Thank you very much. Any final words? My final word here is many thanks to both our panelists, who are not only expert in this, but are willing to have a great conversation back and forth around some of the issues that are involved. I know that this is an area which, as you hear, is emerging. Let's put it that way. But it's also from a legal standpoint, an area where there's a great deal to be done. And as you heard, the process is just beginning, whether it's at the student level or at the professor level or the practitioner level. There's lots and lots we can do to help shape this if we get involved and work on it. So those of you with interest, I would urge you to view it as an opportunity. And thank you both so much for helping lay out that opportunity.